Hello there, everyone. We're back again for, what do we have here that we're going over? Real estate principles and introduction to real estate. And today we're going to be going over chapters 6 through 10. Okay, so we hope everybody's doing good out there. It's a beautiful day today, so hopefully everybody can sit back and relax and we can talk about a little real estate and move forward. So here we go, chapter 6. And also, if you have any problems with seeing any of the words on the screen on this other monitor here, just know that I'm going to be telling you what page it is pertaining to in the chapters. So there's no reason to actually worry about having to read everything on my display, because that's a lot more for me than it is for you to be able to keep up with what I'm talking about. So here we go, chapter 6. Public records. So in chapter 6, we're going to talk about constructive notice in public records. This notice given by the public records and by visible possession, coupled with the legal presumption that all persons are thereby notified. Okay, so you're going to be notifying everybody, sometimes referred to as legal notice. So constructive notice is legal notice also. Also, public records, inquiry notice. A person interested in the property is also held by law to be responsible for making further inquiry for anyone giving visible or recorded notice. And then you have actual notice. And this is knowledge based on what one has seen, heard, read, or otherwise observed. This is on page 84, by the way. So let me get back to page 84 on here. And I wanted to also mention on 84, they talk about until the enactment of the Statute of Frauds in England in 1677, determining who owned a parcel of land was primarily a matter of observing who was in physical possession. Okay, that's what we talked about a minute ago. The landowner gave notice to the world of a claim to ownership by visibility by occupying the land. Hey, I'm here, world, know that, and I can put up a flag, I can, put up other things on the land saying that I'm here. We did that when we landed on the moon. We actually put a United States flag on the moon. So that was saying to the whole world, hey, we're here on the moon, everybody, this is our land. When the land changed hands, the old owner moved off the land and the new owner moved onto the land. After 1677, written deeds were required to show transfer of ownership. Okay, so how do we transfer ownership? Especially here in Tennessee, it's transferring by a deed. All right, so that is that. Recording acts, okay? So this is 85. So recording acts, this is to provide for the recording of every instrument, i.e. a document by which an estate, interest, or right in land is created, transferred, or encumbered. Within each state, each county has a public records office. Okay, you can go down to the courthouse and have a public records office in your city, known voraciously as the county records office, county clerk's office, circuit court clerk's office, county register office, or bureau of conveyances. Again, it's usually on your town square or real close to downtown of your city. Mortgage electronic registration system. This is kind of new. The mortgage electronic registration system is a computerized book registration system of tracking the beneficial interests or bundle of rights connected with both residential and commercial real estate loans. And remember from our prior chapters of the bundle of rights, have all those rights there, and it is pertaining to that and also is recorded. And that way everybody knows that you have ownership to that property. Okay, so on page 85, we have a figure at the bottom. This is the recorder's role there at the records office. The public recorder's office serves as a central information station for changes in rights, estates, and interests in the land. Okay, so you see there in the diagram, it's again on page 85. And they have options to purchase, deeds, mortgages, long-term leases, goes all the way around, and this is what the Public Records Office does, okay? They keep track of all this. Unrecorded interests. Although recording acts permit the recording of any estate, right, or interest in land, many lesser rights are rarely recorded, okay? So month-to-month rentals, leases for 1 year or less, they're usually not recorded, okay? It's usually recorded when a deed gets transferred. Prospective purchasers are presumed by law to have inspected both the land itself and the public records, okay? That's on page 86. Let's see if there's anything else I want to say on that. Let's see the next slide here. Okay, requirements for recording. Okay, it's very important. You have a witness, you have acknowledgement. Okay, so here under witnesses, in states that accept witnesses, the person executing the document signs in present of at least 2 witnesses. So 2 witnesses have to be there, who in turn sign the document indicating that they are witnesses themselves. Okay. In the event that witness's signature is contested, the witness would be summoned to a court of law and under oath testify to authority of the signature itself. Okay, so they'd be brought into a court of law if anything is questioned. Then you have acknowledgement. And here on page 86, an acknowledgement is a formal declaration by a person signing a document that he or she, in fact, did not sign the document. Okay? So it's a formal declaration by a person signing a document that he or she, in fact, did sign the document. Okay, so they did sign it, did not sign it, did sign it. That's acknowledging that. So here it is. This is a page 87. They have it says acknowledgement, and it has the state of, county of, on this blank date of blank year before me, the underside notary public for the state. Again, a notary public is a person that witnesses your signature, and then they can sign as the notary in your city or state. Anyone can be a notary. You just sign up with your city and state, and it goes in front of a board, and they say, okay, let's see if this person is worthy of being a notary. Is he trustworthy? Is he a good citizen in the community? There's several different factors they look at, but most of all, if you've been a good person and don't have a track record of anything illegal or anything, then they should grant you to be a notary. So they have this document here has them actually sign on it. Public Records Organization. Okay, on page 88. Keeping records is an important aspect of real estate process and considers the following. Okay, so you have chronological filing, tract indexes, grantor and grantee indexes, title search, and then chain of title. Okay, let me look here. So the chain of title, this is the linkage of property owners that connects the present owner to the original source of title. Okay, so it's a whole chain. It's like a big solid metal chain, if you want to think of it that way, of all the different links of people that are connected with the property all the way back into whenever they started recording the records. And then you have abstract title. So abstract title is a complete historical summary of all recorded documents affecting the title of a property. Okay, so it's an abstract. It recites in chronological order all record grants, conveyances, recorded easements, mortgages, wills, taxes, liens, judgments, pending lawsuits, marriages, divorces, etc. that might affect the title. The abstractor will summarize each document, note the book and page or other source where it is found, and give the date it was recorded or entered. Okay? So that's abstract of title. That's on page 91. Let's see if there's anything else. The chain must be complete from the original source of title to the present owner. Okay? We talked about that. If there are a missing link, okay, if there's a missing link somewhere, the current owner does not have valid title to the property. So you got to make sure that all links are there. In addition to looking for grantors and grantees, a search must be made for any outstanding mortgages, judgments, action pending, liens, and unpaid taxes. That's one of the largest things that is out there for a title or deed not to be able to transfer is unpaid taxes. Because the state's going to get their money before you get to be able to have your land. So that's what, that may affect the title, okay? And also the transfer of the deed. Ownership proof, okay? So how do I say that I own this property? Two important aspects of providing ownership are abstract of title, okay? This is opinion of title or certificate of title, right? And then title insurance. So you have a title commitment, policy premium with that title insurance, you have a lender's loan policy, claims or for losses, growth of title insurance, marketable title, and quiet title suit. Okay, so let me look at here, page 92 we're on. And also we have that on page 93, a title commitment is more like a snapshot that shows the condition of title at a specific moment in time. Okay, it's just like pictures, it's a snapshot. A title commitment does not tell who the previous owners were. It only tells who the current owner is. All right. So, moving on. And this is page 92 we're still on. And it shows you on page 92 a title commitment. And they have it laid out here. Schedule A, Schedule B, and Schedule C. Okay, if you want to just look that over. Title insurance. The basic principle of title insurance is similar to any form of insurance. Many people pay a small amount into an insurance pool, just like usual, that is then available if any one of them should suffer a loss. Okay, so everybody throws their money in, and if somebody has a claim, then it pays for that claim. In some parts of the United States, it is customary to purchase the title insurance policy through the attorney who reads and certifies the abstract. Elsewhere, it is the custom to purchase it from a title company that combines a search and policy in one fee. Okay, so they'll say, okay, we got to have a title insurance policy, and that's what we do whenever we, after we have a contract between two people to buy a house. Okay, they have to do it's a title insurance, and they go back and make sure that everything is good with the title. There's no liens, encumbrances, all that other stuff, and also in case in the future. So they usually charge not too bad for it, but depends on the house and what location it's in, everything else. But bigger houses may be a bigger title insurance policy. So that is part of the closing documents usually. Title commitment. So here on page 93, they show, and you see, again, Schedule A, B, and C. Just look in your book there. And a title commitment is more like a snapshot, again, that shows a specific moment in time. Okay? So this is just another slide on that. The Torrens system. Torrens system is a system of land title registration that starts with a landowner's application for registration and the preparation of an abstract. This is followed by a quiet title suit in which all parties named in the abstract and anyone else claiming a right of interest to the land in question may attend and can be heard. Okay, so you can have a public forum and have people actually be heard about the abstract. This is on page 97. Okay. So, going back a little bit, with the policy premium, when a property is sold, it is insured for an amount equal to the purchase price. This insurance remains effective as long as the borrower, owner, or heirs have an interest in the property. Okay? It's in the policy premium. Just talk about policy premium. Each time the property is sold, a new policy must be purchased. Okay, so the old one's gone, you got to purchase a new one. All right? loan policy. In addition, title insurance companies also offer what is called a loan policy. This gives title protection to the lender. You always have to give protection to the lender because the lender is not going to lend you money if they don't have any protection of insurance or anything else, because they'll lose money, and banks do not like to lose money. This gives protection to the lender who has taken real estate as collateral for a loan. Okay? So that's a loan policy. Note that the lender's policy covers only title problems. It does not ensure that the loan will be repaid by the borrower. Okay? And there's other things for that situation. So this only pertains to the loan policy there. Claims for losses. Okay, again on page 95. The last item in a title policy is a statement as to how the company will handle claims. When an insured defect arises, the title insurance company reserves the right to either pay the loss or fight the claim in court. Okay, and be brought to court. If the company pays the loss, it acquires the right to collect from the party who caused the loss. All right, so they're going to go after somebody, try to get that money back. The growth of title insurance. 4 important factors have caused the title insurance business to mushroom, to actually just grow like crazy. First, in a warranty deed, the grantor makes several strongly worded covenants. Second, a grantee is also motivated to have title insurance. Third, the broad use of title insurance has made mortgage lending more attractive and borrowing a little easier and cheaper for the real property owners. And then fourth, title insurance has made titles to land much more marketable. And then we get to the marketable title that we talked about before. It's title that is free from reasonable doubt as to who the owner is. Even when the seller makes no mention of the quality of the title, courts ordinarily require that marketable title be conveyed. All right? So that's marketable title. And then we talk about quiet title. Sometimes a stronger means is necessary to remove title defects. For example, the distant relative may refuse to negotiate, or the lender may refuse to remove a mortgage lien despite pleas from the borrower that it has been paid, or there is a missing link in the chain of title. Remember the missing link? Can't have that. The solution is a quiet title suit. A judge acted on a claim. The result is to recognize legally those with a genuine right or interest and to quiet those within a genuine interest. All right? So that's the quiet title. And here we talked about marketable title on page 98. Excuse me. At least 10 states have Marketable Title Act. It's legislation aimed at making abstracts easier to prepare and less prone to error. Okay? Marketable Title Acts do not eliminate the need for legal notice, nor do they eliminate the role of adverse possession. And we have the key terms here: abstract title, actual notice, chain of title. All these, please be familiar with these for the test. And I'm ready to give the Chapter 6 code. So everybody get a piece of paper and write down the code. And the code is abstract. A-B-S-T-R-A-C-T. Abstract. So that's the code for Chapter 6. So I'm going to close out of here. And we are going to go to Chapter 7. There's a lot of information in all these chapters, so make sure you read everything, and especially do all the review questions, because that's a big part of the test. Okay, here's Chapter 7. It's so exciting, isn't it? We're going to do contract law. Wow, that's an excellent topic for real estate, because contracts are what you want, because that's how you get paid with what? Commission when it's sold that is laid out in the contract. Okay, so let me go ahead and start this little slideshow here we got from the beginning. Chapter 7, contract law. So as you're seeing, there's a lot of different factors for real estate. you can't practice law, but you deal with law. And that's why we have E&O insurance that we have to cover as real estate agents, because sometimes there could be something wrong with the recordings or the contract or whatever else being disputed, and we have to have insurance in case somebody sues us. It's called E&O insurance, errors and omissions. Okay, so with law, so what's a contract, right? A legally enforceable agreement to do or not to do a particular thing. All right, 103, we're on page 103. Types of contracts include, okay, so you have expressed, which is a declare. You have implied, which is created by an action. You have bilateral, promise exchanged from a promise. All right. Unilateral, promise exchanged for performance. And then other contract, which a promise to forbear or not to act. Okay. So forbearance, we'll talk about here on page 104. Forbearance, for example, a lender may agree not to foreclose on a delinquent mortgage loan if the borrower agrees to a new payment schedule. Okay, so they'll forbear and they'll do a new schedule for you so you can repay the loan. They're going to be doing that a lot coming up with since we had the COVID and everything. A lot of people don't have enough money to actually make their mortgages, so the banks are working with people to be able to redo their loan situation and pay maybe smaller increments in payment. So we'll see where that goes. Okay, legal effects on contracts. So classifications for the legal effect of contracts include valid, okay, meets all requirements of the law. You have a void, no legal effect, and is not a contract, okay? It's void. It's not legal. Voidable, okay? One party is bound, but not the other, okay? You can have one party that's an adult that's doing a contract, and then there's an underage person. Well, it's voidable because they're not of age. It's not legal. It wouldn't be void. It's still voidable. So unenforceable may have been valid at an earlier time, but now enforcement has bared. Unenforceable could be that the person has become mentally incompetent for some reason, maybe an accident or whatever else, and not able to continue with the loan. Contract essentials. Okay, this is on 107. For a contract to be legally valid, the following 5 requirements must be met. 1, legally competent parties, right? We talked about that a minute ago. Legally competent. Number 2, mutual agreement. Number 3, lawful objective. 4, consideration or cause. And then 5, contract in writing when required by law. Okay, so we have see here. So we have competent parties again. So competent parties is a person considered legally capable of entering into a binding contract. And then power of attorney, a document by which one person authorizes another to act on his behalf. Now when you get married, or if you're married, then you can get a power of attorney on your spouse. So you can actually close a loan on a contract without your spouse being there to sign. You can actually sign for them by them giving you the power of attorney. And usually that's set up by an attorney, and that way you'll say in by my power of attorney, my name, and then I'm signing for so-and-so. Okay, so it's a long drawn-out thing where the signature goes. That's power of attorney, and anybody can get that as long as it's set up prior to the closing. Counteroffer. Okay, so I saw counteroffer here. Good. That's on starts on page 107. Counteroffer, any change in the terms. Okay. Upon receiving the offer, the offeree has 3 options. They can either to agree to it, reject it, or make a counteroffer. Okay. So they have it there at the end of the contract. They say, okay, if you agree, check here. If you reject it, check here. If you want a counteroffer, check here, and then make another page offer. It's called a counteroffer page, and fill all that out of the new counteroffer that you're going back to the seller with, or the buyer. Either way, an offer can be revoked by the offeror at any time prior to the offeree hearing of its acceptance. So you have to accept the offer, and once you accept it, then it's pretty much in stone. So it's a binding contract. So if the next day after a binding contract, if you're not totally sure, you better start talking to people, because every day you go past, the time of actually signing that contract, it gets deeper and deeper into, being enforced. So make sure when you sign the contract, you are ready and willing to purchase or ready to sell, because it is a binding contract and you can be brought to court and have charges filed. So, requirements of a mutual agreement. That's page 108. Let's see if there's anything I have on there. No. Mutual agreement requires that there be no fraud, misrepresentation, or mistake in the contract if it is to be valid. Okay, you have fraud, which I'm going to say something else about here in a second. An act intended to deceive for the purpose of including another to give up something of value. Okay, that's fraud. Right here, under that, 108, if a real estate agent commits a fraud to make a sale, and the deceived party later rescinds the sale contract, not only is the commission lost, but explanations will be necessary to the other parties of the contract. Okay? Moreover, state licensing laws provide for suspension or revocation of a real estate license for fraudulent acts. So the real estate commission of your state will actually hear the case, and they have a board, real estate board, and they'll go over and they'll say, hey, is this did this person do this accidentally, commit fraud, or they do it on purpose, or whatever else, and they can charge fines up to tens of thousands of dollars, depends on what the fraud is, and also you could get your license revoked or suspended for a period of time. So it's serious business. You don't want to be trying to pull one over on somebody, because everything is looked at very seriously, because it's buyer beware, and that way they make sure that the real estate agents are doing exactly what they're supposed to be doing. So, innocent misrepresentation. That's the next one. Party providing the wrong information is not doing so to deceive another for the purpose of reaching an agreement. So they're not really doing it to try to deceive somebody. So it's innocent misrepresentation. Well, sometimes you'll still get it. If you tell a prospective tenant that there's a bus service, okay, only to learn the day after the tenant moves and the service stopped last week. Hey, you didn't know that. Nobody told you. You didn't get a text on it. Why didn't somebody tell me the bus service didn't end? This is innocent misrepresentation. Although there was no dishonesty involved, the tenant still has the right to rescind the contract. Okay, so they're talking about maybe a tenant being in a rental condo somewhere, and there's not a bus anymore coming around picking up people and bringing them to the city. So that's their little example. Then you have a mistake. Okay, arises from ambiguity in negotiations and mistake of material fact. All right, so under mistake, this is on page 109. Suppose that you show your apartment to a prospective tenant, although neither of you is aware of it. There has just been a serious fire in the apartment. Okay, because a fire-gutted apartment is not what the two of you had in mind when the rental contract was signed, there's no mutual agreement. Okay? Ignorance of the law is not considered a mistake. And remember that. One more time. Ignorance of law is not considered a mistake. So they can still get you. Duress. So this is use of force, menace, threat of violence, or undue influence, unfair advantage. Cannot be used to obtain an agreement. Okay? You cannot get an agreement under duress. Right? So use of force, violence, or an unfair advantage. Okay? Lawful objective. To be enforceable, a contract cannot call for the breaking of laws. All right? So do not break the law. They don't like that. Consideration. An act or promise given in exchange for something. So exchange of promises, valuable consideration, good consideration, and multiple meanings of the word. Okay? So they have here exchange of promises on 110 page. In a deed, the consideration requirement is usually met with a statement such as, for $10 and other goods and valuable consideration, also the purchase contract is part of the consideration and is legally merged into the deed. In a lease, the periodic payment of rent is a consideration for the use of premises. All right? So that's the exchange of promises there. Okay, so we have valuable consideration. We talked about that. A contract fails to be legally binding if consideration is lacking from any party to the contract. Then you have good consideration, and as such fulfills the legal requirement that consideration be present. All right. And then multiple meanings of the word, okay? Because a word has three meanings in real estate, you need to make sure what meaning you're actually using. Okay? Statute of frauds. Okay? In each state, there is a law that is commonly known as a statute of frauds. Its purpose is to prevent frauds by requiring that all contracts for the sale of the land or an interest in land be in writing and signed to be enforceable in a court of law. Okay? So that's a statute of frauds there. And that is on page 111. E-Sign Act. Okay, this came around not too long ago. The purpose of the E-Sign Act is to repeal state law requirements for written instruments as they apply to electronic agreements. Effective on March 1st, 2001, which to me, 2001, it wasn't that long ago. But to you guys, it's probably like, oh my God, 2001? What are you, crazy? That was a long time ago. It authorizes electronic agreements. So we were high-tech back then, too. Allows for electronic signatures, and state may supersede this legislation. So they might say, no, we don't accept electronic signatures. You're going to have a real signature. So it all depends on what state you're into. Performance. Okay. Most contracts are discharged by being fully performed or executed by the contracting parties in accordance with the contract terms. So this is performance. That's on page 113. Breach of contract. So hopefully you never have to have a breach in contract, but it happens. Breach in contract is a failure without legal excuse to perform as required by a contract. So, you have partial performance, unilateral rescission, money damages, specific performance, liquidated damages, mutual rescissions, statute of limitations. Okay, so we have all these broken down, and we have novation. Let me see if novation is on the next one. It is on the next one. The substitute of a new contract between the same or new parties. And I have something about novation I'll tell you. For example, novation occurs when a buyer assumes a seller's loan and the lender releases the seller from the loan contract. Okay? With novation, the departing party is released from the obligation to complete the contract. So novation is to release somebody from the contract. Hey, you're out of here. No problem. You have no legal right to it anymore. So, then we talk about breach of contract. Partial performance, they say first. Page 114. Partial performance may be accepted to the innocent party because there may not be a great deal at stake, or because the innocent party feels that the time and effort to sue would not be worth the rewards. Okay, so when they bring you to court to sue, they got to get a lawyer. It costs money. You got court costs, everything else. If it's not that big a deal, they're not going to try to sue you because it costs too much, or they might not get any money out of it anyway. Unilateral rescission. This is the innocent party can take the position that if the other party is not going to perform contractual obligations, then the innocent party will not either. So I say, hey, I'm not going to perform either. So we're unilaterally cutting the contract. Lawsuit for money damages. If the damages to the innocent party can be reasonably expressed in terms of money, the innocent party can sue for money damages. All right, that's able to do within the contract. Lawsuit for specific performance is an action in court by the innocent party to force the breaching party to carry out the remainder of the contract. Doesn't matter if you're going to get the place or not, according to the precise terms, price, and conditions agreed upon the contract. So they can actually, the court can say, no, there's no reason that you're not going to close this house just because you don't like the bathroom wallpaper. We're going to make you go through the contract because it's already all set up, and that's the deal. There's no other reasons. But there would have to be a court of law to do that. If you win your lawsuit, the court will force the seller to deliver title to you as specific and specified in the contract. That's on page 115. Liquidated damages. It's on here too. Page 116. Once the seller accepts the offer, if the buyer fails to complete the purchase, the seller may keep the buyer's deposit. Okay? This is called the earnest money for liquidated damages. So a lot of times, so if you go into a new subdivision and you go to a builder, let's say it's, I don't want to use wrong builders here, but say it's XYZ builder, all right? And you say, yes, we want to go ahead and build on that lot. That lot is beautiful. We just love it. It's got trees in the background, got all the different animals coming up, and we want to build this house. So you get a contract spec, and you say, this is the house we want. So, okay, the builder says, all right, sounds good. Let's go ahead and write up a contract. Well, the builder is going to want a earnest money put down. And earnest money is money that says, yes, we're serious about this purchase. Here's our money, and we're putting it down on the house. So in case something happens to the contract, they get to keep the money. Okay? A lot of builders, they want $5,000 down. Some want $10,000 down. Depends on how big the house is. So if you void that contract, or if you back out, they say, yeah, you can get out of the contract, but we keep your $5,000. And guess who that happened to? Me. So you might as well take, $5,000 and burn it, and then flush it down the commode, because they want all your money. That because of specific performance with contract, you're obligated to go through with, but if you back out, then you lose your money. So just whenever you go to purchase a place or a home, make sure you're confident that you're going to go through with the whole contract, because they may be able to keep your money. Novation, again, the substitution of a new contract between the same or new parties. So what they'll do, they'll substitute, they'll write up a whole nother contract, and they can either throw the other one away, like we talked about before, or they can substitute this one for the other contract with new regulations or whatever else inside that you guys come up with. Deceased party. Okay? If one of the contracting parties die, a contract is considered discharged if it calls for some specific act that only the deceased person could have performed. Okay? So, a lot of times a contract will die with the person that passes away. So, that does happen. So again, key terms again on chapter 7. That's the statute of limitations was one thing that I wanted to mention. On 116 again. Limits by law the amount of time a wrong party has to seek the aid of a court in obtaining justice. Okay, this is a statute of limitations. You have a limited number of time to file suit. Okay, with the court of law. The aggrieved party must start legal proceedings within a certain period of time, or the courts will not help them. Time limits of 3 to 7 years are typically for breach of contract. So they give you a long time, a breach of contract, 3 to 7 years. Depends on what state you're in. Okay, so just remember that. So moving right along, that's chapter 7, and get your piece of paper out because we got another code coming up. The code for chapter 7 is duress. D-U-R-E-S-S, duress. So, well, look at there. It's one of the key terms, too. So, chapter 7 code is duress. Let's go to chapter 8. So much law to have to keep up with. And the state test, you will actually have a state law portion, and you'll have this portion that is all the different rules and regulations of real estate, but then you'll have the state law rules and regulations, and it's a separate test, but you have to pass both of them to be able to get your license. So each state has their own. All right, so chapter 8. Make sure you do the repeat questions. Okay, we're going to study them up real good. Real estate sales contracts. All right, so we're still pretty much dealing with law and contracts. All right, so chapter 8. Purpose of a sales contract. The purpose of a sales contract is to allow time to ascertain that the parties can each perform the terms of the agreement, which are written and signed promises to perform. I'm signing this sales contract because I'm going to perform my end of the bargain, okay, between the two parties. With real estate, one of the biggest things for realtors to do is to keep up making sure that everything in the sales contract is being done. You usually have about between 35 and 40 days to get everything accomplished before that closing. If something's not accomplished before that closing, then you don't get your commission check at the end of the closing because it's not going to close. So it's time sensitive, the whole thing. A lot of times I say it's like cat wrangling. You have to wrangle up all these cats all the time and say, hey, is this done? Is inspections done? What about the walkthrough? Is that done? Just everything. So it's a lot to keep up with, but it's like, you know, wrangling cattle or kitty cats or whatever you can think of. Purchase contracts. Purchase contract contains 4 key parts. Okay, 121 we're on. Provision for the buyer's earnest money deposit. We talked about earnest money. That's the money put down saying, yes, I'm serious about this, and I'm putting down this amount. For a medium-sized house, a lot of times it'll be between $1,000 and $2,000. For a big, grand house, some people put down up to $5,000. Just saying that, yes, I'm serious, I want to buy this house. The buyer's offer to purchase. Okay. The acceptance of the offer by the seller, and provisions for the payment of brokerage commission. All right, so you have to have down what the brokers, everything is negotiable about commission. Commission is something that is back and forth, and all depends on your broker, what kind of commission is going to be allocated. And a lot of times it's between the broker and the party and the client that they're actually selling the house for, or they're doing whatever service for. Earnest money deposit. Okay, we're talking about it again. This is very important. Earnest money deposit, money that accompanies an offer to purchase. Shows buyer's good faith. Yes, I'm ready to do this. No law governs the amount. Okay, so it can be any amount. You can put down $1. You know, in the contract, you put down earnest money amount. You put $1. Right? It's all in the contract. All this stuff, all has to be written out because there's been 1 million lawsuits over all this throughout the years. So everything is written out. No guesswork. Next one is earnest money is not consideration. And then not required for valid contract, okay? So the contract can still be valid without earnest money. You don't have to have it, but usually people do because it gives good faith. Contract terms. The terms of the contract include information regarding, okay? This is on page 122. Yeah, deed and condition of the title, closing agent, prorating taxes and insurance, okay? Prorating everything for the end of the month, for whenever you close on it. Inspections. A lot of times, you're always going to see a home inspection now. Possession, when are you going to move into the house? Loan conditions, what kind of thing you're working out with the bank, if you with a mortgage company. Additional conditions on there, you write all that out. Property damage, you write down if there's any property damage. Buyer default and time limits. Okay, when do you want to close on this? So in the contract, that's one of the first things you talk about. When do you want to close? Because as soon as that contract gets signed, you call up your attorney, your closing, the title company, and everybody else, and say, hey, we want to close December 31st. And they say, great, let's see if we can get you down on that date. And I don't know how many closings I have on that date, but they have to put you down, and that's what starts everything. Once that's put down, then after everything's signed, then you are going to work everything you can to get to that date and close on this thing so you can move forward to another contract or whatever else with another party. So, and also you can pay all your bills because you get paid when it closes. Time is of the essence. Okay, we've had people in our profession that some clients that say, "What is the hurry? You know, why is this time sensitive?" And this is a legal term, which means the time limit set by the contract. Again, the contract must be faithfully observed, or the contract is voidable by the non-defaulting party. Okay, so if they're not holding up their end, you can void it. Due to the legal nature of this term, it should not be used by the real estate agent. Okay, so time is of the essence for the contract. Additional contract terms. So you got signatures of the people, you got acceptance, notification, federal clauses, lead-based paint disclosures. Well, we're going to be talking about all these coming up. Pre-printed clauses, riders, and negotiation. That's on page 129. And in these other pages here, they just give you a example of a real estate contract, okay, and how it's all written out and everything. So just look over all of them. You don't have to know every little line and all that other stuff. Again, this is just a broad look at everything. So, on 129 we have, we talk about times and then signatures. So lead-based paint, I'm going to go over that. The federal law requires that before a buyer or a tenant becomes obligated under a contract for sale or lease, the sellers and landlords must disclose known lead-based paint and lead-based paint hazards and provide available reports to buyers and tenants. Okay, this is since 1978. That's a big year right there. It's on the state test. You'll see. 1978 is when lead-based paint was passed. What happened was, back in the days, back in old times, when they painted a place, it actually had lead in the paint. So after so many years, the paint would peel off the walls, and a baby would go up. And you know how babies put everything in their mouth. They put a piece of paint chip in their mouth, and they would get lead poisoning. and it's not good. It can actually cause retardation and other things, so it's a very bad situation. Here it is, approximately 3/4 of the nation's housing built before 1978 contains some lead-based paint. Federal law requires that before a buyer tenant, like I said before, becomes obligated under a contract or lease, the seller and landlord must disclose the possibility of lead-based paint, hazards, and available reports along with pamphlet protecting your family from lead in your home. Okay, so there's all kinds of pamphlets out there that most companies will give to the person if it's prior to 1978 about the paint. Then you have binder on page 132. A short purchase contract used to secure a real estate transaction until a more formal contract can be signed. Okay, this is a binder. We talk about a rider here on page 132 also. Rider is an addition annexed to a document and made a part of the document by reference. That's a rider. Rider is usually written, typed, or printed on a separate piece of paper and stapled to the document. Negotiation. One of the most important principles of purchase contracts, okay, is negotiation. Is that nearly everything is negotiable and nearly everything has a price. A solid contract results when the buyer and seller both feel that they have gained more than they have given up. Okay? You always feel better when you sign the dotted line. Boy, I'm getting this and that and all this other stuff too. This is great. So it makes you feel good about the purchase and that you're getting more than you're giving up. So, and a lot of times it's your money, but letter of intent. Okay. So letter of intent used to express a mutual intention to buy, sell, lease, develop, or invest. Outlines agreements of terms. No obligation is created. The letter of intent is usually found in connection with more complex transactions, such as commercial leases, real estate development, construction projects, and multi-million-dollar real estate sales. So, practicing law. Here it is. If the pre-printed form requires extensive cross-outs, changes, and riders, the contract should be drafted by a lawyer. Don't go in there and try to make all kinds of different changes to a contract. I've seen it before. People will go through it and they'll just cross out an initial, saying, no, I don't believe in this. No, I don't believe in this. No, I don't want that. And trying to change the contract itself with all the definitions and legalities throughout. You really don't want to do that because every time you cross something out, it makes it less binding. So a real estate licensee is not a license to practice law. So just because you have a real estate license on your wall doesn't mean that you can practice law. You have to have a law degree to do so. They want to make that perfectly clear to everybody. Other types of contracts. You have installment contracts, option contracts, lease with option to buy, right of first refusal contracts. There's bunches of contracts out there. Okay, so on 134, installment contract combines features from a sales contract, a deed, and a mortgage. Okay, that's installment. The most important feature of installment contract is the seller does not deliver a deed to the buyer at the closing. Rather, the seller promises to deliver the deed at some future date. The widest use of installment contract occurs when the buyer does not have the full purchase price in case or is unable to borrow it from a lender. All right. Remember, the job of the real estate agent is to determine the business details of the transaction and not to practice law. A real estate license is not a license to practice law. Again, so I have 2 slides in here. Again, these slides are made up from the people that made the book. Okay, I didn't make these slides. That's why the slides are exactly what the book says. So that's why the slides are pretty much for me to be able to stand on course and not for you to have to actually look at and study. Because as long as you read the book, then you're looking at the slides. Then you have key terms again: binder, earnest money deposit, equitable title, all those things we talked about in this chapter. Let's see if there's anything else I want to mention here. With the option contracts, the option contract is unilaterally executed contract. Once the contract is executed, the buyer then has a right to purchase the property with no obligation to do so. Okay, that's the option. You have an option to buy or not. In commercial real estate, it is quite common for large companies wanting to select sites in a given area to obtain 5 to 10 sites, knowing that they may never actually build on the sites, but it's an option to build. So they'll go ahead and make that option. They'll give money towards that. Then you have a lease option to buy here. It allows the tenant to buy the property at a present price and terms during the option period. For residential property, the lease is typically for 1 year, and the option to buy must be exercised during that time. Okay, so that's a lease to option to buy. Right of first refusal. Sometimes a tenant will agree to rent a property only if given an opportunity to purchase it before someone else does. Okay, this is on page 139. Right of first refusal. If someone presents the owner with a valid offer, the owner must show it to the tenant before accepting it. Have to show it to the tenant. If the tenant decides not to match it, the owner is free to accept it. So, that's a right of first refusal. So, get out your piece of paper again. These chapters go pretty quickly. So, the chapter code for chapter 8 is earnest. So, not Ernest Scared Stupid, like you've seen, during Halloween. Ernest, the guy that likes milk. But this is actually earnest for earnest money that you would put down on the house. So EARNEST is the code for chapter 8. Moving and grooving right along, we're going to hit chapter 9 and 10. And that way I can film all these at once. And you guys can do the first 3 chapters and then do the next 2 chapters the next week. So this way we have everything set up, ready to go. So we're going to go ahead and move right to chapter 9. Mortgage and note. Wonderful. These topics are so much fun. All right, mortgage and note. So I got pinned up a note right there. Okay, 143 through 145. Promissory note. This is a contract between a borrower and a lender, also referred to as a real estate lien note. So you have an obligor and an obligee. Okay, the or is giving, right? The gee is receiving, right? You'll see that all through real estate in this semester also, that it's or and e at the end for giving the or and give me. Then you have the principal, you have acceleration clause, and a signature. Okay, so obligee, the borrower. This is on page 144. Borrower states that he has received something of value and in turn promises to pay the debt described in the note. So it promises to go ahead and pay. The principal, or amount of the obligation. Okay, so it's the amount. It's not the principal person, it's the amount is the principal. So in a mortgage, it'd be the $100,000 is the principal. So you have acceleration clause. This allows the lender to demand immediate payment of the entire balance remaining on the note if the borrower misses in any of the individual payments. Remember, the note is what binds you to your payment every month. Okay, my mortgage payment's $1,300. I need to go ahead and pay that. Well, that's your note. And if you don't pay it, then they come and they give you acceleration clause. Doesn't sound too good. So, borrower misses any of the individual payments. The lender can only foreclose on the payment that have come due and have not been paid. All right, you can't foreclose on future payments on it. Only the ones that haven't been paid and up to that point, okay, of the of them defaulting on the payment. So we have the mortgage insurance instrument. Okay, mortgage. What is a mortgage? A separate agreement from the promissory note that provides collateral to the lender to back up the promise made in the note by the borrower or mortgagor. Okay, so who is the mortgagee? In this case, receiving the money is the mortgage company, the bank. Okay, mortgagor, giving, all right, is the person that's buying the house. You're the mortgagor, you're giving over the money, they're receiving the money, so they're the mortgagee. So it gets confusing. You always have to see who's giving, who's taking. All right. So that is that with that. We have covenants coming up. Covenants, what are covenants? These are promises. You go to church, they have the different covenants to the Lord. These are promises you're making to the Lord. What are the 10 commandments? Well, they're almost like 10 covenants. Thou shalt not kill, I promise not to do this and that, The mortgage contains a list of covenants that the borrower makes to the lender, including the covenant. So you have to pay your taxes, against removal, of insurance, of good repair, and of preservation and maintenance. You're making sure that you're going to take care of this property, because guess what? You don't own that property until you pay the whole note and pay the bank everything you owe them, and then you get a certificate saying your mortgage has been completed, you've paid up all the money, and now it is yours. But until then, you have to make these promises saying that you're going to keep the place in good condition and that everything's going to maintain in good repair. So, covenant to pay taxes. The borrower agrees to pay taxes on the mortgage property even though the title may be technically within the lender. Covenant against removal. The borrower promises not to remove or demolish any buildings or improvements during the time of the mortgage. Okay? All those years. Covenant of insurance requires that the borrower carry adequate insurance against damage or destruction of mortgage property. Covenant of preservation and maintenance requires the borrower to keep the mortgaged property in good condition, like we talked about a minute ago. Gives the lender permission to inspect the property to make sure that it's being kept in good repair and has not damaged or demolished. So, alright, I've owned over 7 different homes. I've not had one time that a mortgage company come out and look at the house and make sure that I'm not throwing Coca-Cola all on the walls and ripping up ripping everything up. It hasn't happened. But right here it says, yes, they have the right to do that. So you never know. You might get a knock on your door one day saying, we're with the mortgage company. We want to inspect the house, make sure everything looks good. And they do that in a lot of the rentals. If you rent, you probably have had the landlord come by and make sure everything looks good. But the same thing holds true with a mortgage company on a house. So, but it usually doesn't happen. Clause in mortgage. So again, acceleration clause. You just permit the lender to demand the balance be paid in full immediately. Accelerate it. Alienation clause gives the lender the right to call the entire loan balance due if the property is sold or otherwise conveyed by the borrower. If you sell it to somebody else, they want their money right off the bat. Also called a due on sale clause. And they will get their money because they'll take you to court immediately and they'll get their money. Condemnation clause. When all or part of the property is taken by action or eminent domain, from the state or city, any money so received is used to reduce the balance owing on the note. Right? So that's a condemnation clause. It's on page 148. So, mortgage satisfaction. Boy, everybody wants to be able to do that. Satisfy their loan, satisfy the mortgage, all paid up, you own the house. Okay? When a loan is paid, the standard practice is for the lender to return the promissory note to the borrower. Here's your promissory note, along with a document called a satisfaction or release of mortgage. That's probably the happiest day you'll ever get, is when you receive that satisfaction or release of mortgage. The grass feels better outside, that the house is paid for. The rooms look brighter. It's a wonderful thing. A lot of people have to wait until they're, up in age to be able to pay all those years in payments. A lot of times they're 30-year loans, but if you're able to pay it off, it makes everything a whole lot nicer. There's a partial release. There's subject to, assumption, novation again, and estoppel. All right, that's on 149, 150. So a partial release. Occasionally, a situation arises when the borrower wants the lender to release a portion of the mortgage property from the mortgage after part of the loan has been repaid. Okay? It's called a partial lease. Subject to, in the purchase contract, the buyer states awareness of the existence of loan in the mortgage that secures it, but takes no personal liability for it. Although the buyer pays the remaining loan payments as they come due, the seller continues to be personally liable to the lender for the loan. Okay, and again, that is subject to, and that's in the contract. Be written up. Assumption here. The buyer promises in writing to the seller to pay the loan, thus becoming personally obligated to the seller. In the event of default of the loan, the lender will look to both the buyer and the seller because the seller's name is still on the original promissory note. Okay, so assumption. My parents actually bought several homes under assumption back in the late 70s because a lot of the houses were being just taken over by that way. You could assume a loan. You can pay so much down and then you take over the note, okay, like they're talking about. And then the last one they did was a huge farm, and they paid the person so much a month, and depending on what interest rate they wanted, they paid them instead of paying a bank or a mortgage company. So it was an individual. So if they defaulted on their loan, my parents, if they defaulted, then the person with the house also would have defaulted. But who's the bank going to go towards? The person that actually, the first person that has the note. So that's assumption. You can assume somebody else's note. Novation, the safest arrangement for the seller is asked to substitute the buyer's liability for his. This novation releases the seller from the personal obligation created by the promissory note. And the lender can now require only the buyer to repay the loan. All right? And then estoppel. This is the borrower is asked to verify the amount still owned and the rate of interest is the estoppel. Debt priorities. Okay, so there's different priorities with debt. You got a first mortgage, senior mortgage, secondary mortgage, junior mortgage. Then you have subordination, chattel liens. All right, chattel lien. What is chattel again? I always said before it's cattle, but it's chattel. I just remember it because it's personal property, right? So my cattle outside is roaming around. It is personal property to me. It's not real property. They're not actually stuck to the ground, you know. And then you have foreclosure and power of sale. So first mortgage on page 151. This is normally accomplished by being the first lender to record a mortgage against a property that's otherwise free and clear of mortgage debt. Okay, so that's our first mortgage. If the same property is later used to secure another note or a second mortgage, before the first is fully satisfied, the new mortgage is a second mortgage. Okay, so a lot of people like to get second mortgages on their house. They say, okay, how much equity do we have in the house? Well, how much have we paid down on the house? So if you buy a house for $100,000 and you pay down to $80,000, well, what is the equity? It's $20,000. Well, you can say to the bank, hey, I paid down to $80,000. I got $20,000 equity. Give me a second mortgage on the house and give me that money, that $20,000 I paid down on it. And what I can do with the money now is go and add a bathroom, put a deck on the property, do multiple things, and use that on the property itself. You can use it on other things too. You can pay down debt with it, which I would never tell anybody to do that, but thousands and thousands of people do that. I closed over, it's called a HELOC, Home Equity Line of Credit, and they use that, and it's kind of like a second mortgage on a house, and it uses that equity, and it gives you a credit line up to that amount, so you can go and use it on anything, right? So we actually use it in investing. We can go and buy a property with that equity and then have a separate mortgage for that from the house. So there's several different ways that you can do it. But you have to be in good standing and have an excellent credit rating and all that stuff. But home equity lines of credit, which are second mortgages on the house, are a wonderful thing. So, subordination. Sometimes a lender will voluntarily take a lower priority position than the lender would otherwise be entitled to by virtue of recording date. Subordination, it allows a junior loan to move up in priority, up to a other loan, right? So a junior might become a senior. It all depends if it's in subordination. Chattel liens here, an interesting situation requiring priority occurs when chattels are bought on credit, okay, personal property on credit, and then affixed to land that is already mortgaged. So if you refinance your house, a lot of times people will roll over all their credit cards into their home, okay? So that meal that you went and had on your Visa card, that $40 dinner you had over at, what's a good place? J. Alexander's. Haven't been there in years, but I hear it. They're usually pretty good. So if you go to J. Alexander's and you buy a $40 dinner, well, you put that on your credit card and you're still paying it off. You start paying interest on that, on your credit card, and then you go and refinance your house and you put that credit card on the mortgage itself, or you're going to be paying off that meal over, 25 years? So that all that interest is, it can add up. So try to keep those things separate from your mortgage. It's not really good to combine everything. Try to keep them separate, because you don't want to be paying off things over years that are just personal property and other things. So you have a delinquent loan. Although non-compliance with any part of the mortgage agreement by the borrower can result in the lender calling the entire balance immediately due, in most cases foreclosure occurs because the note is not being repaid on time. So that's delinquent. You don't want to be delinquent, okay? These are mortgages and notes on page 153. There's a diagram that they had out there. You see the borrower defaults, there's negotiations with the borrower, and then lender accelerates the note, okay? And then it goes down all the different things all the way down to actually the lender getting the money from the courts back, okay? So there's a lot of different steps there, and it's it's actually in the book. 153, judicial foreclosure, okay? So we have surplus money action, and then the other ones. I'm going to go through these. Notice of lis pendens, public action, equity of redemption, deficiency judgment, statutory redemption, and strict foreclosure. On page 153, surplus money action. The junior mortgage holder hopes that the property will sell at a foreclosed sale for enough money to pay all senior claims, as well as his own claim against the borrower. Okay, that's a surplus. Lis pendens. This notice informs the public that the legal action impending against the property. Okay, the property and prospective buyer, upon making a title search, will learn of the pending legislature. So it's put out there to make sure that everybody knows about it. Okay? public auction. Okay, they have public auctions on the courthouse steps all the time. They actually put it in the newspaper on what day and time that they're going to have a public auction. You can go to those auctions. You can buy things. They have tax sales, which is at the public auction. Just be careful of what you do with that. You want to do your research before you go out there. We actually went to a public auction. We thought we were getting a house and land, and actually it was just land. There wasn't even anything on it. We were very naive at the time, very young, and so we went out to the property, and there was no house. There was just property. So we thought we were getting the house pretty cheap. Well, we never did even get the house because it was just land. So be careful what you're doing. Do a lot of research. Public auction. The objective is to obtain the best possible price for the property by inventing competitive bidding and to conducting the sale in full view of the public. To announce the sale, the judge orders a notice to be posted on the courthouse door and advertised in the local newspaper, which was I said earlier. Equity of redemption. This privilege to redeem property at any time between the first sign of delinquency and moment of foreclosure and the borrower's equity of redemption. If no redemption is made, the bidding begins. Okay? Deficiency judgment. The borrower is still personally obligated to the lender. If there is an amount that it sells for and that they still owe, then the borrower is still may be sued for that money. Only a judge can award a lender a deficiency judgment. Okay, so you have to go to court for it. If the property sells for an obviously depressed price in its foreclosed sale, deficiency judgment may be allowed only for the difference between the court's estimate of the property's fair market value and an amount still owing against it. Okay, so that's what I said. It sells for less than what's owed, what's worth, then you might have to pay it. Statutory redemption laws and foreclosure. Borrower has, depending on the state, okay, from 1 month to 1 year or more after the foreclosure sale to pay in full the judgment and retake title. So, if you go to a foreclosure sale and it's tax, because the tax is not being paid, a lot of times you'll have to hold on to that property for a whole year before you do anything to it. Because they have a whole year to come back and pay those taxes and be able to get that property back. Alright? So, you gotta be careful with that. Again, a lot of people don't know when they're going up there. Oh man, I didn't know they had a whole year to be able to come back and pay the taxes. Usually it doesn't happen because if they didn't have the money before, they're sure not going to have it now to pay the taxes. So, all depends. Depending on the state, the purchaser may or may not be possession or have possession until then. So you might not even be able to get on the property until a whole year goes by. Knowing this, bidders tend to offer less than what the property would be worth if title is possessed, could be delivered immediately after the foreclosure sale. So that's why a lot of places, well, we got this $300,000 house for $175,000 because it was a tax sale, and we just got a deal because we have to wait a whole year before we can go in the house, right? So you get a better deal. A lot of people make a lot of money on that situation. They'll wait the year, they'll put a little bit of money into it, they'll turn around and make all that money back, or even more. So you can make $200,000 on a house by doing that. That's a lot of jack. That's, a couple years' wages there for most people. Strict foreclosure. Last one is a judicial foreclosure without a judicial sale, and usually without a statutory redemption period. Okay, that's a strict foreclosure. Strict foreclosure is a predominant method of foreclosure in 2 states and is occasionally used in others. Okay, so again, it's without a judicial sale and usually without a statutory redemption period. Next is other methods of foreclosure. Okay, power of sale, entry and possession, deed in lieu of foreclosure, and installment contract foreclosure. I'll run over those real quick. Power of sale. Okay, in 27 states, the predominant method of foreclosure is power of sale. gives the lender the power to conduct the foreclosure and sell the mortgage property without taking the issue to court. Entry in possession based on the lender giving notice to the borrower that the lender wants possession of the property is on page 156. The borrower moves out and the lender takes possession, and this is witnessed and recorded in the public records. Deed in lieu of foreclosure is a voluntary act by both borrower and lender and is sometimes called a friendly foreclosure. If either feels regular foreclosure proceedings would be advantageous, no agreement is reached. And then you have an installment contract. State legislature found installment contracts too often one-sided in favor of the seller, especially where the buyer had made a substantial number of payments and or the property had appreciated in value. As a result, many states have enacted legislation that requires installment contracts to be foreclosed like regular mortgages. Okay, they just have to be foreclosed in many states. Deed of trust. Okay, this is a huge document in the closings. Okay, every page of the deed of trust usually has to be initialed. Initial each page of the deed of trust, please, because they want you to read it. Most people don't, because it's all legalities, attorney written and everything. But they might read it later after the closing when they have more time to do so, because it's 15 pages sometimes. Deed of trust. There's a three-party arrangement consisting of the borrower, the trustor, the lender, the beneficiary, and the neutral third party, a trustee, also known as the trust deed. Equitable mortgage. A written agreement that, although it does not follow the form of a regular mortgage, is considered by the courts to be one. Okay, equitable mortgage, it's on page 157. Security deed. Okay, a warranty deed with a reconveyance clause. Security instruments found many paths, but always with one goal in mind: to get money to the borrower, who uses it and then returns it to the lender. Okay, security deed. All right, and here we are. Key terms again. You got acceleration clause, foreclosure, mortgagee, mortgagor, promissory note. Talk all about those, okay? So, again, go over the review questions and be familiar with key terms. And what are we up to right now? We're up to getting a piece of paper out and writing down the chapter code for chapter 9, and that code is foreclosure. That's something you never want to know or someone to tell you that is happening to you is foreclosure. So foreclosure, F-O-R-E-C-L-O-S-U-R-E, foreclosure is the code for chapter 9. Keep it on going. We're going to go to chapter 10. Just take 1 second here. This is the last chapter we're going over. And this chapter starts on page 163. This is the deed of trust. That's what I talked about. It is usually around 15 pages, and it's a lot to it. Go ahead and slideshow from the beginning. Chapter 10, deed of trust. Parties to a deed of trust. Who are the parties? We're not having a big party. We're just going through this document, we're going to sign it, and we're going to go through the rest of the closing. But parties to the deed of trust. When a promissory note is secured by a deed of trust, 3 parties are involved. Okay? Borrower, which is trustor, lender, which is beneficiary, and neutral third party, which is the trustee. Okay? Right here, the lender makes a loan to the borrower, and the borrower gives the lender a promissory note, which we already know. In the deed of trust, the borrower conveys title to the trustee to be held in trust until the note is paid in full. The deed of trust is recorded in the county where the property is located, and is then given to either the lender or the trustee for safekeeping. Anyone searching for the title records would find the deed of trust conveying title to the trustee. All right? So, titles of trustees. All right? So we have naked title, right? A title that the borrower grants to the trustee. A title that lacks the rights and privileges usually associated with ownership. So again, naked title is lacking rights and privileges, and it's known as a bare title. Reconveyance or release deed is a document used to reconvey title from the trustee back to the property owner once the debt has been paid. That's a reconveyance or release deed. They release it. Okay, so we have a diagram here, comparison of, and this is on page 164, comparison of a deed, mortgage with deed of trust, okay? So at the beginning you have a mortgage or lender at the top. They got the arrow going down to the borrower, right? Paying down the note, then it goes back up to the mortgage lender as note and mortgage, all right? So it's just a roundabout. The deed of trust over here is more of a triangle situation. You have the loan down to the borrower, you got naked title to the trustee, then deed of trust going back up to the lender. And then they just show it when the loan is made, okay, and then when the loan is repaid. They have it there. Deed of trust document. This is on 165. The purpose of the deed is to provide security for the promissory note and mortgage. In other words, although this deed grants and conveys title to the trustee, it is understood that the quantity of title the trustee receives is only that which is necessary to protect the note. This permits the borrower to continue to possess and enjoy the use of the property as long as the promissory note is not in default. So you can use it, party on it, do whatever you want, as long as it's not in default. They have on page 167, so a request for full reconveyance. They have on figure 10.3, and they have to the trustee. It's written out here. They have a debt, they have a date there, and also a beneficiary, which is signed on there. Also, a full reconveyance underneath that, figure 10.4, is on page 167. You have the trustee, you have the trustors, you have the date. It actually recorded an instrument, and it has the book number, page, county, state of, and then signature there, and then the trustee's signature. All right, so that's the next. Jurisdiction using deeds of trust. Okay, this is just a list of jurisdictions. The deed of trust is customary security instrument in the following states. Okay, so they have all the states written down. You got Alaska, Arizona, California, Colorado, District of Columbia, Idaho, Maryland, Massachusetts, Minnesota, Mississippi, Missouri, Nebraska, Nevada, North Carolina, Oregon, Tennessee. Okay, we use it here in Tennessee. Texas, Virginia, Washington, and West Virginia. The deed of trust is also used in a certain extent in Alabama, Delaware, Hawaii, Illinois, Montana, New Mexico, Utah, and a few other states. Okay, comparison of mortgage deed of trust and a land contract. Okay, so at creation you see a mortgage and then deed of trust and land contract, all three of them, and how they branch off of each other. That is on page 169 on figure 10.5. And mortgage has two off of it. Note to lender and mortgage to lender. Deed of trust has two off of it. Note to lender, deed of trust to trustee. Then you have a land contract, which comes straight down, land contract with seller. Okay, that's at creation. And then at foreclosure it shows you, and then at repayment. Okay, it just kind of breaks it down to where it's a little bit easier to understand what's going on there. Advantages of a deed of trust. Popularity of a deed of trust can be traced to the following attributes. If a borrower defaults, the lender can take possession of property and collect rents. Okay? The time between default and foreclosure is relatively short. Foreclosure process under the power of sale provision is far less expensive and complex than court-ordered. And the title is already in the name of the trustee. Once the foreclosure sales take place, there's usually no statutory redemption. It's on page 170. Also, the property can be purchased subject to, all right, an existing deed of trust, or it can be assumed, just as with regular mortgage. Deeds of trust can be subordinated, and partial releases are possible. Now this just breaks down, and most of the chapter actually has deed of trust with power of sale, and it's mostly just showing you the different documents that are assigned. So it's a very quick chapter. It's only 4 pages long. It looks like 5 pages. So they want to harp about the deed of trust, because the deed of trust is one of the most important documents in the closing documents. Again, I said before, the closing documents can be 80 pages long. So it could take you up to 30 minutes to actually do a closing, because you're signing, all these papers. You have carpal tunnel syndrome by the time you're done with it. But we're now down to the end of this video with chapters 6 through 10. Okay? Chapter code for chapter 10. Get out your piece of paper, and we're going to write down beneficiary. Okay? A beneficiary is a wonderful thing, because that's who's getting whatever's given to them by another party. So my insurance policy, my beneficiary is my wife. So my life insurance, if I pass away, she gets the whole policy. Her beneficiary after my wife is my son, so it keeps on going down. So beneficiary is a nice term to know, and that is the code word for chapter 10. But in conclusion, this with law and everything else, there's a lot of information, and just know that you can't practice law without a license, and we are not lawyers, we're real estate agents, so we can only try to help people read the law and try to understand as much as we do. We can, but if we don't know it, it's good to have a lawyer to talk with if you're doing any kind of contracting. My closing attorney is actually a real estate lawyer and attorney, so it helps out having somebody in the closing to do that, and that way they can explain the documents as you're going through them. So that'll be it for chapter 6 through 10, and thank you for watching, and we'll be back with chapter 11 coming up soon. So have a great rest of the week. Thanks.